Good afternoon, everyone. Thank you for joining us for the October episode of Kelleher and Holland's monthly Lunch and Learn webinars. Before we get started, if you have a question at any time during the webinar, please type it in the Q&A question box that's located in your Zoom control panel, and we will make sure to address it at the end of today's presentation, given the amount of time we've got left. We are fortunate to have three panelists with us today. From our employment law group, we have Andy Bowling and Madeline Kelleher, and from our litigation group, Michael Morrison. So for you panelists, my lunch-related question today, before we dig in, is favorite pizza toppings. What are yours?
I'll go first. Pepperoni, usually anything with pepperoni on
More cheese.
it.
Hot sardinera.
Ooh, I would say all three of those together sound great. So last month we talked about the changes in Illinois law regarding the Illinois Paid Leave for All Workers Act. And today we are here to discuss the amendments made to the Illinois Day and Temporary Labor Services Act. So Madeline, can you start us off today by telling us about the Illinois Day and Temporary Labor Services Act and its purpose?
Absolutely. Thanks, Amy. So on August 4th of this year, Governor Pritzker signed a bill that significantly amends the Day and Temporary Labor Services Act, and these changes are effective immediately. They provide temporary workers with strengthened equal pay rights and protections with several new safety and training requirements. So generally, the Illinois Day and Temporary Labor Services Act protects the labor and employment rights of day and temporary laborers. The enactment of this act in 2000 was prompted by the Department of Labor's findings regarding the then current statistics of temporary workers and day and temporary service agencies, which are commonly called temp agencies. And these statistics included over 300,000 temporary workers in Illinois, approximately 150 registered temp agencies in Illinois with around 600 branches, the existence of a large, though unknown, number of unregistered temp agencies operating outside of the radar of law enforcement, the findings that temp agencies often abuse temporary workers' labor rights, with some of the most significant being failing to pay wages entirely, failing to pay for all hours worked, failing to pay minimum wage, failing to pay overtime, and taking unlawful deductions from pay for meals, transportation, equipment, other items. Um, and lastly, the inadequacy of the law to protect labor and employment rights of temporary workers. So, in summary, the purpose of the act is mainly to provide temporary workers with labor rights and then ensure those labor rights are enforced through the state's registration of temporary agencies.
So Mike, can you tell us who exactly is affected by this new act?
Sure. There's primarily three groups of folks who are affected by the act. The first being the day or temporary laborers themselves, meaning any persons who contract for employment with a temp agency. Secondly, are the temp agencies themselves, meaning persons or entities engaged in the business of employing day or temporary workers to provide services for a fee or to a third party client pursuant to a contract with a temp agency and a third party client. And lastly, are the third party clients, meaning the persons or companies that contract with the temp agencies for obtaining the temporary workers. One thing to note here that nonprofit day labor centers that charge no fee for those services are not subject to the new provisions of this act. So, something to be aware of there.
So Andy, can you give us a bit of a definition of what exactly a day and temporary laborer is?
Yeah, I'll try, Amy, and I'll preface this by saying that our legislature has done us no favors in trying to provide clear guidelines, but I'll do the best we can with the information that we have so far. The amendments do not change the definition in the existing statute of day and temporary labor. The essentially, it means anybody who is engaged in heavy mental, manual, mechanical, or physical work. The administrative guidelines to the existing statute indicate that professional work who are excluded from the statute, that they will look to federal wage and hour law to determine that definition. And a professional, under the applicable terms of the Fair Labor Standards Act, is any person who meets the duties tests of a professional and who is engaged in work predominantly intellectual and varied in character, as opposed to routine mental, manual, mechanical, or physical work. Now, under the federal guidelines, it's not just people who are standing on an assembly line who would qualify as covered labor. Anybody engaged in a trade, an electrician, a plumber, a carpenter, would also fall within the definition of a covered employee under this statute. Now, our laws do not define what is clerical work, and there is no federal counterpart. Historically, employers have understood this to be essentially an office and production breakdown. That if you're in an office sitting behind a desk, and even if you're eligible for overtime, you're probably engaged in clerical work. And I think we can also look to sections of the existing statute that focus on where such staffing agencies can be located. The law says that they can't be within a certain proximity of churches or schools. And so I doubt that there are no such restrictions in agencies that are placing, for example, IT workers or accountants. So there's some confusion. Watch this space in the weeks and months ahead as we wait for court decisions and regulations.
Thanks, Andy. So Madeline, let's talk a little bit about the changes that were made to this act.
Sure. So, due to consistent findings that in the inadequacy of the law to protect the rights of temporary workers, the significant amount that still exists of and is probably increased of unregistered temporary agencies, and the doubling of both the amount of temporary workers and the temp agencies in Illinois, the act was amended to add rights and safety protection for temporary workers. The most significant are 4 amendments, which we will go into more detail about throughout the presentation. But a brief overview are: 1, it mandates that temporary workers assigned to a third-party client for more than 90 days be provided with benefits and be paid at least as much as the comparable lowest paid employee directly hired by the third-party client. These 2 changes, benefits and pay, comparable pay, are called the equal pay for equal work provisions. Next, we have the new amendment requiring both the temp agency and the third-party client provide temporary workers with training specific to the job site at which the temporary worker has been assigned to work. Third, giving temporary workers the right to refuse an assignment to a work site where a strike, lockout, or quote-unquote labor trouble exists. And fourth, expanding the Act's private right of action by granting additional parties the ability to initiate civil action for a violation of the Act. However, these changes in the Act leaves several unanswered questions that are likely to cause some confusion for trying to ensure compliance with the amendments.
So Andy, Madeline mentioned there's a lot of unanswered questions so far for these new amendments. How are these lingering questions that are unanswered be resolved?
Well, the Illinois Department of Labor has issued 3 days after the governor signed the legislation, emergency rules that provide some additional direction, and we'll be talking about them at various points in our presentation. On August 18, the IDOL issued proposed permanent rules, and there's a comment period that will remain open for a few more weeks. Right now, we're working under the emergency rules, which are very similar to the proposed permanent rules, but I think that there will be a combination of additional regulations and court guidance as this statute works its way through our legal system.
So Mike, when must a temporary worker receive equivalent pay and benefits?
So the Equal Pay for Equal Work Amendment to the Act continues Illinois' commitment to maintaining wage transparency and classifying workers as employees rather than independent contractors. They place obligations on temp agencies as well as third-party clients that utilize temporary laborers. And those obligations include temp agencies must pay temporary workers, as Malin indicated, at least the rate of pay and equivalent benefits as the lowest paid directly hired employee performing the same level of work at the same level of seniority. Now, you may be asking, what if my company doesn't have a comparable employee of that level, of that seniority? The Act tries to address that concern by stating that if there's not a directly hired employee that could be comparable against that hired worker, the temporary worker must be paid not less than the rate and equivalent benefits of the lowest paid directly hired employee of that client. Additionally, as if that wasn't enough, the temp agency may pay the hourly cash equivalent of the actual cost of the benefits as opposed to actually providing the benefits. The second thing to note here, upon request, the third-party client to which the temporary worker has been assigned for more than 90 calendar days is now obligated to timely provide the temp agency with necessary information related to the job duties, pay, and benefits of the directly hired employee. Also, upon request, the third-party client to which a temporary worker has been assigned for more than 90 calendar days is now obligated to timely provide the temp agency with necessary information related to job duties and pay and other benefits. So with these new amendments, third-party clients that utilize temporary workers should anticipate that temp agencies will be requesting this kind of pay rate information and should develop a protocol for gathering and providing that information. Additionally, third-party clients should expect temp agencies that they have their own contracts with to renegotiate the pay structure of such contracts to comply with the new equal pay for equal work provisions of the Act. So a lot of maneuvering going on there in terms of pay and 90 calendar days and all that. So a lot to be aware of there.
So I keep hearing all of you mentioning 90 calendar days. So how are these calendar days actually calculated to determine the need to comply with this equal pay for equal work provision?
So, unfortunately, this is one of those questions left unanswered by the amendment, which also prompts additional questions, including one, what is the start date from which the 90-day period is measured? Two, does the requirement that the temporary worker be assigned for more than 90 days include non-working days? And three, do the 90 days have to be consecutive? Now, the Department of Labor's new rules, briefly discussed by Andy earlier, answer a few of these questions. As for the first, it appears that the start day from which the 90-day period is measured is the first day that the temporary worker performs work for the third-party client. As for the second question, there's still no direct answer. All the Department of Labor's rules say is that increased pay and benefits are required as of the temporary worker's 91st day of performing work for the third-party client. As for the third question, the Department of Labor's rules say that the 90 days must be within any 12-month period, but can be consecutive or intermittent. However, these rules provide that temporary workers who are already working for third-party clients before the amendments will not automatically receive increased pay and benefits. So, as mentioned earlier, temp agencies will be seeking to renegotiate their current contracts to ensure compliance with the new amendments to this Act.
Let's go into some of the new workplace safety and training requirements. Mike, if you want to give us some details about that.
Sure. In addition to an employer's already existing obligations to follow OSHA safety standards, this Act now also requires compliance with its own set of safety and training requirements that both temp agencies and the third-party client must comply with. Let's talk about the temp agency's obligations first. First, at the start of each new contractual relationship, a temp agency must do essentially 5 things. First, inquire about the client's safety and health practices and hazards at the work site where the temporary worker will be working, to assess the safety conditions, the tasks, and the client's safety program. This could also include a visit to the client's work site to check on these issues. Secondly, they must provide training to the temporary worker for general awareness regarding recognized hazards that the worker may encounter at that work site. This may be done in the preferred language of the temporary worker and provided at no expense to the worker. Thereafter, the training and the content of the training must be maintained by the temp agency and given to the temporary worker. Next, they must send a general description of the training program that it provided to the assigned workers, including the topics covered and the client provided to the client upon the commencement of the contract. So the client's in the loop on this. Next, they must provide the temporary worker with the Department of Labor's hotline phone number in order to report safety concerns and hazards. And then finally, they must inform the temporary worker who he or she should report safety concerns to at the workplace. Then, on the client side of things, they must do 4 things. First, document and inform the temporary agency about anticipated job hazards likely to be encountered by the temporary worker. They must review the safety and health awareness training program provided by the temporary agency to determine if it addresses the recognized hazards for the client's industry. They must provide specific training tailored to the particular hazards at the client's worksite, and they must document and maintain records of site-specific training and provide confirmation that the training occurred to the temp agency within 3 business days of providing that training. Thereafter, if circumstances within the job or location to which the worker is assigned changed, and a new hazard presents itself that may be encountered by the worker, the client then must do 2 additional things. They must inform the temporary worker and the temp agency of the new hazard or location, and inform the temporary worker and temp agency of the new job hazard that was previously covered before the temporary worker undertakes the new tasks, and updates any PPE or training for the job tasks as necessary. If a new hazard is encountered, then generally speaking, a temporary worker may refuse to perform any new task if that task has not been reviewed or if the temporary worker has not been provided with the appropriate training for that new task. Additionally, if the temp agency becomes aware of an existing job hazard, whether during this initial inquiry or any other time during the contract, the temp agency must make the client aware, urge the client to correct the issue, or they can remove the worker from the worksite. Under the Act, the client is required to allow the temp agency to visit any of the work sites where the temporary worker is assigned in order to confirm the client's training has been done specific to the job tasks and safety and everything else they're required to do under the Act. So obviously a lot of new requirements here for both the temp agency and company side of things. So a lot to be aware of on the safety and training side of this Act.
Andy, what kind of labor disputes give a temporary worker the right to refuse an assignment?
I'll backtrack just a bit, Amy, by giving some key background here. This amendment was intended in large measure to strengthen the hand of labor unions in Illinois in the case of strikes and other labor disputes. And these provisions create some potentially serious ramifications for employers, both staffing companies and the third-party clients, as they are referred to in the Act. The amendments grant the workers the right to refuse assignment to a location where there is a labor dispute. And they also require the day and temporary agencies to inform them in writing in the language that they can read and understand, which may be Spanish or Polish, as mentioned in some of the guidance, or other languages. And this gives them the right not to accept the assignment. Now, A labor dispute is defined as any controversy concerning wages, hours, terms, or conditions of employment. It's much broader than a mere work stoppage or a strike. And this vague definition could be interpreted to cover myriad employment-related controversies, including even actual or threatened litigation over such things as wage and hour, or harassment or discrimination practices. And really, what this will do is make it much more difficult for employers who, in the face of a strike or work stoppage, might try to introduce temporary workers into the work site to keep things going.
So did the amendments that we've been talking about change who can recover under the Act?
Yeah. So prior to the amendments, the only two entities that could recover under the Act were the temporary worker and the temp agency. Now there are two more entities that can recover under the Act, including the Illinois Attorney General and interested parties, which are defined under the Act as an organization that monitors or is attentive to compliance with public or worker safety laws, wage hour requirements, or other statutory requirements. So this can include other interested parties such as OSHA or the Department of Labor, and arguably even includes labor unions or independent compliance monitors. So the Illinois Attorney General can now request that a circuit court suspend or revoke the registration of a temp agency when it's warranted by violations of the Act. And additionally, interested parties have the right to initiate civil action against a temp agency or third-party client. While the responding party is granted an opportunity to cure any issue, this does not prevent the right to sue from being issued by the interested party. Overall, these amendments are likely to result in more litigation of claims involving temporary workers, with the ambiguity of the new provisions of the Act and the additional parties who are now able to have a right to sue.
So Andy, what are the potential penalties for non-compliance with the Act?
Well, they're formidable, and I would compare them initially to some of the damages and remedies that are available under the Biometric Privacy Act, which applies in Illinois. If there's a wage and hour dispute, the employee can recover the amount of wages, the value of the benefits, and any other compensation denied or lost. And the temp agency can also sue their employer clients for breaches of this policy, plus an amount of liquidated damages equal to the actual loss. So this could be formidable depending on the number of workers. For a health and safety or notice violation, the employee can recover compensatory damages in an amount up to $500 for each violation of a section of the Act. And in the case of retaliation against someone who speaks out in favor of their rights under this law, they can get all legal or equitable relief as may be determined by the court. Obviously, another gap that will be filled in later. And then in all cases, the party whose rights have been violated gets to collect their attorney's fees. Now, there's a couple things I want to highlight that could be real traps, particularly for temp agencies and their client employers. Remember, the penalty for unregistered temp agencies is $500 per each day they operate without appropriate registration. And the clients can be subject to a civil penalty in the same amount for each day they are contracted with an unregistered temp agency. And this is why employer clients must re-verify their agency registration on March 1 and September 1 of each year.
So Mike, do the Department of Labor's rules impose any penalties in addition to those under the Act?
No, they don't. However, the rules do clarify that in determining penalties, the Director of Illinois Department of Labor shall consider the following factors when determining a penalty. Number one, the seriousness of the violation, including the nature, circumstances, extent, and gravity of the violation. including probability that death or serious physical harm would occur, the severity of the harm that occurred, and the extent to which the provisions of the applicable statutes or regulations were violated. They also shall consider the economic harm to the laborer caused by the violation. They also shall consider the history of previous violations. They also shall consider the amount necessary to deter future violations. Also, the effort by the temp agency or third-party client to correct the violation. And lastly, kind of the catch-all, any other matter that justice may require. So clearly a lot of discretion given here to the Department of Labor in handing down penalties for violating the act.
So in our last few minutes, Andy, if you wouldn't mind summarizing our presentation today and leave our listeners with some webinar leftovers and maybe some action items on what they can do now.
Sure, let's walk through some action items. First, audit your company's use of temporary labor to determine if you have exposures. Second, and this ties in with the audit, if possible, and if you are potentially exposed in Illinois, consider the viability of restructuring your operations so that your use of temporary labor falls outside the boundaries of Illinois. At this point, it appears that if, for example, you were to have employees working in another state, they would not be covered because this law only extends protections, as we read it, to individuals within the boundaries of Illinois. Third point, establish a point of contact at your day and temporary employment agency to make sure that you can reliably communicate and share information as required. And then if you're a third-party client, meaning most employers, you need to proactively track the number of days each day or temporary worker has been assigned to work at your company, and be aware of when the 90-day mark is approaching so that staffing decisions and corresponding compensation adjustments can be made in a timely manner. And again, this will require close coordination with your staffing company. Next, prepare and maintain updated records of compensation data for directly hired employees, potential worksite hazards and efforts to mitigate or control those hazards, and keep track of labor disputes so that you can provide appropriate notices to your staffing agencies. Another takeaway is prepare targeted safety training specifically for day or temporary workers about the potential hazards at your company's work sites, and make sure that you have a good protocol for documenting the fact that the training was given in a language that the employees could understand, and then be prepared to compensate day or temporary employees for any workplace training.
Thank you, Andy. And thank you all panelists for all the great information. We've had some questions come in. We have a couple more minutes and we will address what we can with the time we have left. And any questions that we don't have a chance to answer live, we will definitely answer one-on-one directly after the presentation. So let's jump right in here. What benefits will be required to be paid by temp agencies for temporary workers that work for a third-party client for more than 90 days?
I'll take this one. So as we learned today, the temporary worker has to be paid the benefits equivalent to that given to the lowest paid directly hired employee of the third-party client, performing at the same level and same seniority and the same substantially similar work. So the equivalent benefits to be given to the temporary worker were not defined under the Act. However, the Department of Labor's rules provide that benefits means healthcare, vision, dental, life insurance, retirement, leave, paid or unpaid, or other similar employee benefits, and other employee benefits as required by state or federal law. So it's pretty broad and has to be equal to that third-party hired employee that is the lowest paid.
We're coming up on 1 o'clock, but we'll squeeze in one last question here. How do you determine what third-party client hired employees to compare to when determining the rate of pay for a temporary worker?
I'll take this one too. So when determining whether a temporary worker is performing substantially similar work, the Department of Labor's rules state that you have to look at whether the job performance required includes substantially similar skill, effort, and responsibility performed under similar working conditions. Um, the Department of Labor further clarifies this test by providing definitions of the terms effort, responsibility, seniority, similar working conditions, and substantially similar work and skill. So that's pretty much the test for determining a temporary worker's uh, substantially similar work as the employee.
Great. So we've run out of time. We do have a handful more questions. We will make sure that we answer those directly with you immediately following today's presentation. So that wraps it up today. We hope that you found this session informative. Thank you for attending. And I have contact information up on the screen for all of our panelists today if you have additional questions later on about today's topic, and we're happy to answer those offline for you. And just a note that our next Lunch and Learn will be on Tuesday, November 7th, and we will be discussing the new earning thresholds for the Department of Labor's exempt versus non-exempt classifications and the significant impact these proposed changes can have on how employers pay their employees and who is or is not entitled to overtime pay. So this is another hot topic fresh out of the oven. You won't want to miss it. So registration for that session will be open soon. Check your inbox or our social media pages for more information, and have a great rest of your day. Thank you.